Maybe,
Yes.
well, the tomorrow one item is listed at item number 7,
Yeah.
read appeal. Well, this is connected to that appeal.
Oh.
So, well, can it be tomorrow? Well?
Okay.
Obviously.
May I pay for an accommodation at number 6 and 7, so I've taken consent of the others. They also have some difficulty with it.
Okay. Who appears for the appellant?
I'm for the appellant.
You're for the appellant?
I'm for the appellant.
Okay, on request made by Mr. KP Patel. Learned counsel for the appellant. When do you want?
Lordship may let it come up in its own course, Your Lord.
After 2 weeks?
After 3 weeks, Your Lord.
After 3 weeks.
Be pleased.
May I please, Your Lord?
Yes.
My Lord, I beg to mention for listing of a fresh rate appeal, my Lord. Matter relates to selection and appointment, my Lord. Some urgencies there, my Lord. May I pray for, my Lord, coming Friday, my Lord. Coming Friday, my Lord.
Coming Friday. Friday, some difficulties. Day after, some difficulty will be there. We'll have it on Monday.
My Lord.
Yeah.
And my Lord, a similar matter regarding, my Lord, selection and appointment of headmasters in upper primary, high schools, my Lord, wherein Rule 14 had been put into challenge, my Lord. My Lord, may kindly on Monday, my Lord. Oblige.
May it please your lordship. Lordship, I beg to mention for listing a contempt case for Friday, lordship. Only notice will go in this case, lordship. I filed it long back, lordship, but not yet listed, lordship. Oblige your lordship. Lord, I'm mentioning a matter not in the list. This is pertaining to, my lord, cutting of trees around this Digholi Pukri.
Okay.
Now, my lord, earlier we moved a PIL where, my lord, a consensus was arrived at. In fact, government came up with a proposal that they are not going to remove these trees. Now they are still killing, my lord, they are surreptitiously they are doing it. So we have filed an IM, my lord. Let it be listed tomorrow. my lord.
Okay.
My pleasure.
Deep-
Actually, I'm paying for a listing of a fresh rate appeal, Lordship. Lordship, actually, what happened, Lordship, earlier also we mentioned.
Monday.
Lordship, we're praying for tomorrow, Lordship, as it was supposed to be listed today, Lordship, because we have already earlier mentioned. And the same was allowed to your Lordship.
Let it come up on Monday.
Can it be tomorrow? Lord?
Monday.
So may I pray for listing of an pending IA for delayed condonation lordship on Friday, your lordship?
It is some
Right.
difficulty.
Monday, lord.
Monday.
Lordship. And Lord, if lordship is willing, lordship, may I pray for listing of an hearing matter, your lord?
It is difficult.
Lordship is willing, lordship.
You take up.
Item 1, for fresh admission, which day?
Okay, none appears for the appellant. List the one.
Item 2.
My lord, here we are challenging the virus of the amendment, my lord. Now, what has happened now, the other than science teachers, they are not being eligible. And even in case of science teacher also, the qualifying service has been made 15 years. Whereas, my lord, the existing teachers of the high school, they are eligible on completion of 10 years. So, my lord, there is absolutely no correlation with the classification and the objects sought to be achieved. In that view of the matter, lordship will examine the matter.
But change order in senior council justice by Mr. RM Deka.
There is one more thing, my lord. They have issued an advertisement based on this. So at least they will not finalize this election, my lord, in the meantime.
Yes, Kaushik.
My lord, in that regard, my lord, I have an objection, my lord. In fact, earlier there is a round of litigation, my lord. In that litigation, there is an order, my lord, can kindly come to page 96, my lord. The observation made by this honorable court, my lord. Paragraph 5.
Yeah.
So in view of submission made by so and so learned counsel for the secondary education department, and as the selection process has not been completed till date, the respondents are directed to make the selection of headmaster of the high school on regular basis in terms of 2025 rules. In view of the fact that the high school have remained headless and they have been run by in-charge headmaster for a long time, the state respondents should ensure that the selection process of headmaster on regular basis is made as expeditiously as possible. So
In
these are
fact-
observation from this
My
order
lord,
to
in
complete the.
fact, my lord, based on this order, the science graduates have been made eligible. It was a petition filed by the science graduate teachers that how come we have not been made given this benefit. So based on this, Milord, they have been made eligible.
No, no, council for the appellant. Oh, for the petitioner.
Or at least, Milord, there are 14 petitioners, 14 posts may not be filled up. Let them fill up the other posts.
Issue not this.
In that case also, madam, others will come and they will pay the similar pay, madam.
Issue not this.
So, madam, may make it subject to the outcome of the requisition, madam.
No, that is the otherwise also will happen without making that observation.
You are appealing for?
Blatantly violative
You are
of
appealing
Article
for the-
14 and 16.
I'm
That's all.
appearing from my
Full education.
education department, madam.
Mr. M.J. Catania and the standing council. Education department, school education department. Appears on behalf of
All the restaurants, madam.
all the respondents. Extra copies. Respondents are allowed to file affidavits. List after 4 weeks.
Yes, sir.
4 weeks.
In any case, in 4 weeks, Milord, they cannot finalize. So let they leave of the court, let them finalize it.
In that case, madam, my lord may consider the prepare for interim, my lord, on the returnable date, madam. In the meantime, I will file the affidavit, madam.
Prayer for interim shall be considered on the next week.
Lordship will say that interim order will be, no, let them have the instruction, Milord. Lordship will fix the matter for interim orders. After
That's why-
After 2 weeks, madam.
Yes.
In that case, after
After
2 weeks.
2 weeks. Prayer for interim shall be considered on the next week.
Lordship, would your Lordship kindly fix the matter on 23rd, Milord?
23rd.
Obliged, lordship.
Item 3.
Deep level.
My lord, here is the case, my lord. While exercising the power, my lord, under section 14 of Subsidy Act, my lord, acted beyond jurisdiction, my lord. Why, my lord? The secured asset, while taking. Hey, this is- Copy I have given, my lord. Name has shown, my lord.
SC has been written there.
Central Bank.
It's.
This one, name has been also shown, my lord.
Mr. Lordship, I am the standing counsel, but
Okay, you finish your copy and.
yes, one extra.
My lord, here is the case, my lord, in the nutshell is that, my lord,
Maybe take
I have-
some.
after some time.
After some.
Okay, finish him a copy, we'll take up after some time.
Yes.
Lost.
At the end of the board.
But the photograph is what I. No, number 24.
Legal Lordship, sincere apologies, I missed item number 1, Lordship.
Yeah,
Lordship, this is a custom
okay,
reference,
let it, we'll take up after some.
Lordship.
Item 4. Corporate admission without stay.
Yeah, please, your Lordship. Lordship, this matter pertains to compassionate appointment, your Lordship. And your Lordship, the order of Honorable Single Judge, your Lordship, at page number 45, your Lordship. Your Lordship, kindly see the relevant portion, your Lordship, at 49. And the main ground, your Lordship,
We consider the matter if not known person. Yes, Saike?
My lord, this is the compassionate appointment. Then this order, there is no infirmity in the order. In terms of the favorable Tiwari.
You
That
get
is
some
the reason.
instructions,
Is
we'll
it-
take up on Monday or Tuesday. Tuesday?
Tuesday.
Okay, heard, Ms. Zipora, Shilani Council. Mr. P. Saike, then of Dr. Civil instructions in the matter. This. Tenth.
much.
My lord, in the respondent number 3 and 1, my lord. ZAD, they have a separate standing council and executive engineer.
But then
PHC also
you
separate
take,
standing council.
I'm not passing any, I'm not issuing any notice, this court. What we are doing is, we are just asking, get some instructions and something.
Item 5. This matter, Lordship, I am appearing for a private respondent, Lordship, and need further 2 weeks time to file our affidavit in opposition, Lordship.
How many times have you taken time? Okay. Mr. A. Das Gupta, Senior Counsel. Assisted by MS. He does, then counsel for the petition. Stop.
NK Sharma.
On request made by Mr. N.K. Sharma.
Lordship. For respondent
Learned
number
counsel
3 to
for the
6.
respondents, 3 to 6.
Here the main respondent is SMR 1 and 2 because we have challenged the validity of a statute.
We have received this pairwise comments, they're not enough. Right back again, I need some time.
How much time?
Well, a month's time, subject to the convenience of this honorable court.
Of
Quick,
course,
let me
it will
quick.
come with the summer
After
vacation.
the
is coming.
holiday, subject,
Okay, MS,
S. Sharma,
S. Sharma, Learned,
junior government.
Senior Government Advocate, appearing for the respondents, 1 and 2. And Mr. N.K. Sharma, Learned Counsel, appearing for the respondents, 3 to 6. I'll put allowed 4 weeks time to file the respective affidavits. Mr.
Yes.
Ian Bhattacharya, Learned Counsel, Learned CGC. Appears for the respondent. Sir.
Item 3.
My lord, I have incurred, my lord, and we have given served a copy to their clerk, my lord. Acknowledged, and I just now I found it, my lord. They have received, my lord.
Where is he now?
Lordship, he's in another court. I'm calling.
Okay, follow up item 1. Learned Counsel.
Item 1.
May I please, your lordship. We have prepared this custom reference against the final order dated 15/1/2025, passed in final order number 7505425, passed by the Honorable Sested, Kolkata, in respect of custom appeal number 75449 of 23, whereby the Sested has set aside the order in appeal dated lordship 28/3/2023 and set aside the confiscation of the gold, stating that the gold was not of foreign origin, lordship. No, lordship, the gold was seized from the, lordship, may come to page 3, para 1, lordship.
Page 3.
3 of the appeal.
Oh.
Lordship, para 1. That on 24/1/2020, the personnel of GRPS Guwahati detected and seized 11 number of gold pieces from the possession of Sri Prahlad Kumar Das while he was on board on DN 14019 Tripura Sundari Express train, which was standing at platform of Guwahati. Subsequently, the said 11 number of gold pieces believed to be of foreign origin, totally weighing 699.310 grams, were handed over to the Anti-Smuggling Unit Customs Division, Guwahati, for effecting formal seizure at the Customs Office, Guwahati. The GRPS Guwahati also hand over the test report of SB assaying and hallmarks stating that the certified gold to have fineness ranging from 99.30 to 99.39%, 23.84 carat. On demand, Shri Prahlad Kumar Das, the owner of the gold, failed to produce any licit documents in support of the purchase, transportation, possession, importation, and in any manner dealing with the seized gold. However, he submitted one blank tax invoice. The Anti-Smuggling Unit Custom Divisions effected seizure of 11 pieces of gold believed to be of foreign origin by seizure case number so and so, dated 24/1/2020, on reasonable belief that it has been illegally imported in contravention of section 7(1)(c) and 11 of the Customs Act. The value of the seized gold is estimated at 27,90,000.
Okay, then what happened?
Now, Lordship, para 2. That Shri Prahlad Kumar Das, the owner of the goods, submitted a blank copy of the original tax invoice bearing number 53 of DCM and CO, 12 Sovaram Barak Street, Bara Bazar, Kolkata, West Bengal, which had nothing recorded in it. He claimed that he purchased the said gold from the above firm. However, he also showed another tax invoice issued by another firm, that is SK Mandal and Co. Nalini Set Road, Sonapati, Kolkata, in his mobile phone, which was sent by his accountant. The tax invoice shown in his mobile phone does not correspond with the statement that the impugned 11 goods were purchased from the firm DCM and Co. and thereby contradicting himself. On going through the statement, it was observed that he has stated that he had traveled from Selda to Agartala, carrying with him the 11 pieces of gold with the purpose of meeting Rohit, a goldsmith, whom he had already contacted over the phone prior to his visit to deliver the gold pieces to him in exchange for gold ornaments. But having failed to meet Rohit, he decided to return to
Then-
Kolkata.
then-
It was Lordship. So Lordship, follow-up investigation was conducted by the Kolkata Custom Divisions, revealed that the.
What is wrong in the, what is wrong in the order?
Lordship, your Lordship may come to page 78
Hmm.
of the sested order.
Yes.
Lordship, the sested has observed that the para 13 Lordship, as it is a case of town seizure having no foreign marking on the gold, and his gold is of different shape, size, and weight, purity of 99.30% to 99.39%. In that circumstance, the gold in question cannot be absolutely confiscated. Therefore, the conditions of section 110 for seizure of gold are not complied with, as there is no reasonable belief. Your Lordship may see section 123 of the Customs Act, Lordship. One 123, Lordship.
Yes.
May I read, Lordship?
Hmm.
Burden of proof in certain cases where any goods to which this section applies are seized under this act in the reasonable belief that they are smuggled goods. The burden of proving that they are not smuggled goods shall be A. In case where such seizure is made from the possession of any person. Roman 1. On the person from whose possession the goods were seized. And if any person other than the person from whose possession the goods were seized claims to be the owner thereof, as also on such other persons. In any case, on the person, if any, who claims to be the owner of the goods so seized. This section shall also apply to gold, watches, and any other class of goods which the central government may, by notification in the official gazette, specify. Lordship, in this case, the SEC has not furnished any licit documents regarding the golds. Lordship,
But later on he produced, isn't it?
Lordship, he has produced two documents, two invoices he has produced, Lordship. Lordship may come to page 10, para I, that is the ground.
Yeah.
Lordship, for that, the Honorable Tribunal has observed that the gold seized in this instant case was found to be of 99.30% to 99.39% purity and did not have foreign marking. However, it is submitted that the purity alone cannot be considered for assessing the smuggling activity. Circumstantial evidence, that is absence of any licit document regarding procurement, transporting, possessing the said gold, involvement of the accused in smuggling case on earlier occasions, contradictory statement of the accused regarding the procurement of the gold and patterns of the movement could establish reasonable belief in the instant case. Further, the absence of markings may also not be considered for dismiss the suspicion, especially when the burden of proof under section 123 lies on the possessor accused, and to which the accused failed by way of not providing any licit document of procurement and giving false and contradictory statement, wherein the accused once provided tax invoice bearing number 53 of DCM and Co. Calcutta, claiming that he had purchased the said gold from DCM and Co. And on 21/2020, on credit basis, and later he provided e-copy of tax invoice of another firm, that is SK Mandal and Co., which indicates that the verified intention of the accused in using the said documents fraudulently, Lordship. Lordship, I also submitted one substantial question of law.
Okay.
I have submitted substantial question of law, Lordship. Three questions arises. Whether the Honorable State Calcutta has erred in concluding that the gold was not bearing any marking of foreign and that the purity of gold is less than purity of foreign gold does not attract 123 of Customs Act 1962. Whether the findings of the learned state that the revenue has failed to make out a case and the impugned order for absolute is liable to be set aside and penalty on the appellants before are not imposable is perverse and contrary to the records. Whether the findings of the learned sister are perverse and contrary to the materials available in the records. Lordship. These three questions arises, Lordship.
Three is not necessary, I think.
Lordship.
Hmm?
1 and 2, Lordship.
1 and 2.
So, Lordship may admit this reference, Lordship, and further stay the operation of the sextet order dated, Lordship, 15/1/25.
Okay, heard, Mr.
Agent.
K. Jain, Leonard, you are the standing counsel.
No, Lordship. I am appearing on behalf of Mr. SCKL.
Leonard Council, appealing on behalf of SCKL, Leonard Standing Council,
Customs,
Customs.
Lordship.
For the appellant. Well. After hearing the Leonard Council to the appellant. The following substantial questions of law are formulated. 1 and 2, no? This one. Issue notice. Appellant to take steps for service of notice on the respondent, sole respondent.
Sole
By
respondent,
registered proceeding within 1 week.
Lordship.
List of performance. We have formulated to substantial question of law now we have formulated. You state for something. The in the entry. The order dated
Lordship, 28/3/23.
final order dated 20
Lordship, 15/1/2025.
15/1/2025. Passed by the learned Sistat. Kolkata. Shall remain suspended till the next session.
I'm obliged, Lordship.
What is this IA?
Lordship, I is for the stay, Lordship.
Then we can close the IA.
Lordship.
IA in view of the order passed in the main appeal, main reference. IA stands dismissed.
Grateful, Lordship.
Item 3.
May I please the lordship? My lord, here in the case is that, my lord, petitioner had 3 loan account, my. Accordingly, my lord, that they have taken action, lordship, can you have a look at page 43? It's the serial number 1, my lord, ABC, there are the 3 loan accounts against which I have mortgaged some particular property, my. Only 3, my. While taking, my lord, reports of section 14, my lord, they have added other account, my lord. Exceeding the jurisdiction, my lord, other 2 accounts. Lordship, can you see page 50, my lord? Which is not a mortgage property or not secured property. And Act says, my lord, it has to be a secured assets, my lord, but it is not then secured assets.
Where's your account?
My account number is the mentioned middle, my lord. para in the middle portion, the applicant bank secured credit within the meaning of the so and so and financial assistance loan to expressly so categorically stated have so and so recovers the account loan account 405, that is not the secured. Next one is also not secured, and other three they are the secured for which they have taken action, my lord. We are also ready facing it, my lord. But section 14 says, lordship, kindly have a look, only secured assets. Page 26, if your lordship is taking same book. my lord. Only secured assets. May I read, my lord?
Mm.
The chief metropolitan magistrate or district magistrate to assist the secured creditor taking possession of the secured asset. But here is the other two account that is not related to secured.
Your Lordship, this is matter relating to the certificates. So first of all, the writ petition itself is not maintained.
Have come
And
in
the second
jurisdiction,
question-
my lord.
I'm. So the second question that has been raised regarding the accounts, that the petitioner has not stated that these two accounts are not of his.
Let
These two
it be,
accounts
but
are of
not
his
secured.
deeds. And besides that, the three
Have
accounts
an
is
ex-
being mentioned correctly. There is nothing. What prejudice has been caused to him? And the asset is a secured asset, and the immovable property which has been mentioned in the section 14 is correctly mentioned. There is no dispute over that. Even if let it be taken that the two account has been wrongly mentioned, how prejudice is being caused to him?
Cannot be, my lord.
That is the case.
Wrong cannot be done.
And the total outstanding amount is not being disputed by him.
That we are facing, my
Everything
lord,
is all
Service Act.
But
But
three accounts are already
three
there.
account, my
Yes,
lord, they are
already there.
come now 5 accounts, which is not secured 2 accounts.
That is all.
Law says against the secured amount, secured property. But against those accounts, that is not secured, my lord, no security. A violation of fundamental rights exceeding jurisdiction.
Not to interfere with service. What is the DRT? No.
And he may challenge before the DRT concern.
That
This
will
question,
my
there is
lord.
no bar of
That,
it.
my lord, now exceeding the jurisdiction, DRT has no power.
No, no, no.
To
That
a
is,
magistrate, my
if-
lord,
if
who has
section 14
acted
has
beyond
been-
jurisdiction. I have come in the violation of fundamental rights.
But you are aware of the Supreme Court judgments?
That is, I know, my lord. I am not on to
They've
that, my
on
lord.
and off, several orders have been passed not to interfere in this.
No, my lord,
You
but-
have to approach the DRT.
Here, my lord, I have come
And
before your lordship,
basically,
my lord.
your-
It's a violation of my fundamental rights. And magistrate acted beyond jurisdiction.
Your Lordship, mentioning of the account number, how the fundamental
That
rights has
is,
been
my lord, my
violated.
property will be auctioned. taken away.
That the DRT can also rectify that.
Rectify the-
Rectify it.
My lord, they have
And
to
we
rectify,
will
my lord.
also rectify.
DRT will not rectify, my lord.
But
I
DRT
have come before your lordship only simple prayer, my lord. They have acted beyond jurisdiction.
but
They
we-
sent the
you-
proposal.
you
They
should-
state also without application of mine pass the order.
You should approach the DRT.
That I'll approach, my lord.
Then
But
you
at this
approach.
moment,
Why
my,
are you wasting
at
court's
this
time?
moment, since there are 2 accounts are not secured accounts, they cannot be given clean sheet to exceed the jurisdiction beyond the law. And beyond the law, the writ court is there. There is also criterion of judgment of our High Court also, apex court. The moment my lord, fundamental right is violated and acted beyond jurisdiction in such circumstances, this petitioner has to challenge before this honorable court under 226, my lord. I have made a categorical statement in para 5 of my writ petition, my lord.
Sharma, you can rectify this order.
Yes, yes,
Let
yes.
them do, my lord, not
Yes.
to act upon.
Yes, we can rectify. it.
When can you rectify it?
Your Lordship, we can have to move another application if that be so the case.
Yeah,
Because I
my
have
lord,
to
in
check
that
up
case,
the
case
facts
can be
also.
disposed of.
And
Yes.
your Lordship, section 14 order is being passed. So DRT has ample power to interfere with the order also. There is nothing like that, that the section 14 order cannot be interfered by the DRT concern. They can raise this issue before the DRT. And they are not denying that these 2 loan accounts are not of the writ
My lord,
petition.
we are facing, my lord, the Surface Act, that is true. But in the name of other 2 accounts, they have come
No,
to take away my
that's why,
property.
but what you can do, you can approach the DRT and then when they approach, they can rectify the order in the
Yes,
before
my
the
lord, let
DRT.
them take the rectification. And whatever legal course, I'll take it. Let them rectify first. I cannot challenge, my lord. That is not a secured account. I have to give some notice for particular loan.
Yes, Shama, who passed the order?
This is
District
the
magistrate.
district magistrate.
Saikya?
As per the request of the time.
They wrongly presented before the mistake.
You take steps.
Yes, sir. We will take steps. But your lordship, my humble request is that only, that this order is very much dealt with by the DRT only.
Oh.
And as far as the payment is concerned, these two accounts are also a loan account of the borrower, who is the writ petitioner.
No, the issue is this. These two accounts are not secured.
We will take out the rectifications.
When can you do it?
Your lordship, that we have to move an application before the DM concerned.
Huh? So you take steps immediately.
Yes.
Today itself you take steps.
Today, not possible, but.
Why not?
Yes, yes.
In that, like, lordship can dispose of my lord. May I leave my lord court? Another matter is going on. My junior brother will be there.
Your lordship, may kindly pass over the matter for the time being. We can take any instructions and come back before you.
It's the last matter. Okay, you take instructions, we'll wait. I'll give you
May
2
take up
minutes.
tomorrow, your lordship. If possible. Because I have to take the full instructions on this, because the reason 13-2 notice has been issued. The entire proceeding has been completed.
Okay. But Mr. I'll record your senior's name. Jay Barbuya, legal counsel for the petition. On request made by Mr. M. Sharma, Leonard's standing counsel,
For Central Bank of India.
Central Bank of India. List the matter again on keep tomorrow's date. In the meantime, if you take steps,
Yes, your lord.
if you take steps,
Will be
today,
inspected
we
accordingly.
can close the
If
matter.
it is a mistake, then I have to take out the rectification bill.
No, see, there's a, this order was basing on the proposal submitted by the bank, your lord.
That's why.
It is the bank, it is the bank wrong committed by the bank.
So that's why they are going to rectify, let him get some instructions and come back.